runoff from 100% or a normal year. That's not going to happen. You're going to need another 20% to 40%. So think about if we have a normal year, you're going to be down 20, 40%. So runoffs are going to be down.
Right.
All we are asking is that we start now with a process regarding non-emergency rules and regs, how we're going to go through this, how this is going to happen, and what we need to look at, and start that process now, which ties into my next comment, is the stakeholder process. Right. We identified a stakeholder process. We've talked initially with Karen on your staff about this. We're very much interested in the stakeholder process about providing feedback to you and your staff about how we can do this better, provide better information, get better feedback, let the regulated community know in a more timely fashion. We were all under the gun last year. You did a very fine job in getting things out. And I commented to Mr. O'Hagan, the charts and graphs, but we need to do more of that and give more definition about when we see these things occurring. But in regards to that as well, though, you have a water quality control plan going on as well. And we've sent you, the board members, a letter. And one of the things we have to learn from the drought is that if we're going to do a water quality control plan, and if we have climate change, we really have to integrate this into our water quality control planning. And to provide certainty for the beneficial uses that we are looking to protect in the watershed, all beneficial uses. The last thing that kind of ties into this is the CSPA filed a complaint, and Mr. O'Hagan was talking about this. You've received numerous letters from the exporters and others. The SJTA has not weighed in yet. We do think, though, that a lot of the factual and legal issues raised by the parties in those letters and/or complaints are very important, and actually we've said this before, they're actually foundational issues for phase 1, phase 2, and any Bay Delta Conservation Plan change petition. We are uncertain as to what that scope and the extent and what the process should look like, and I understand your staff is trying to work on that as well. We have a group of attorneys that have been discussing this on the outside. I think it'd be helpful if we met with your staff, if that's okay with you, and talk about how we can formulate a process that could get to a review by the board and an order that would resolve factual and legal issues in a way that we just don't go through, because I've heard this term, a Bay Delta adjudication. I realize we would ask you to, in your quasi-adjudicatory fashion, to render a decision, but in our view, we don't need a basin-wide adjudication of the entire Sacramento-San Joaquin Bay Delta. If that would be agreeable with the board, we would like to contact your staff and see if we can, on the outside, develop some framework and what the factual and legal issues that need to be developed and looked at, and present it to your staff in a way that makes sense, that we can have a limited focus ability to deal with the issues that have been presented to you. Because that issue, I think you all realize, and I think your staff realize, going into next year, it isn't going away. It's going to be here, and as we go through less storage and less runoff and trying to meet X2 requirements, we're going to have to deal with that issue. So those were my points.
Very thoughtful.
Any questions for me?
That's good. Karen, did you want to comment? I know staff is trying to figure out how to be most efficient and effective with everybody's time. And so any suggestions you all have, of course, is helpful. But do you have any suggestions for format? And really, the fall is approaching, and we want to be prepared and don't want to do the sort of hair on fire decision making if we can avoid it this year. And that includes pulling together the real-time operations folks and the other agencies. So.
Part of what John was describing earlier was the evaluation that we're undertaking right now, looking at both the letter that came in from the projects as well as the CSPOS complaint and all the other responses that are posted on our website if anyone is interested on the Dry Year homepage. But we're trying to go through that assessment as well right now, and what is the most efficient approach to addressing those letters, complaints, informational requests, et cetera. So we would be happy to meet with Mr. O'Laughlin and hear any ideas that the group that he's been working with has on how to approach this as well.
Yeah,
I think
and-
that's great. There's also the other suite of issues that he raised that are all things that are on our agenda. So I think we're going to want to update on how you propose to get ahead of all those curves.
Certainly, and I'll just
Sooner than later.
mention that at last week's drought task force meeting, the question about the lifting of curtailments came up within that meeting itself. And we have been working on pulling together some information that we would provide to curtailed water right holders to update them on the status of the curtailments, efforts to lift them, to address, be able to account for storm events that may occur, et cetera.
I
So
remember that was always the plan, to be able to notify people even online so they would know, they wouldn't be waiting for a letter as the rain was falling.
Absolutely. We want to be able to do it in as real time as possible.
Yeah, and every watershed's different and
Right.
every location. So we all understand that. So
Right.
basically what we'd like to do is just start meeting with your staff and going through those, because all those are separate. You know, the stakeholder process is different. It ties into what we're going to do next year, whether or not you adopt rules and regulations this year going into next year. Because given the water year, I mean, it's pretty clear that we're going to probably be in at least a post-14 curtailment next year, even with average rainfall. Great. Thank you very much.
Thank you.
I
Sobering,
appreciate it.
thoughtful. Appreciate it, too.
Thank you.
Terrific. I do want to take a morning break, and we'll take a little bit of a later lunch. I don't know how, I'd kind of like to get to item 7, if that's all right with you, before we take a break. And then everyone but our public hearing and all the people here for the executive director's report can leave. All right, item number 7, please. Thank you, guys. Thanks for all the hard work.
Good morning, Chair Marcus and members of the board. My name is Wenelin Fua with the Division of Financial Assistance. This item requests the board's consideration of a resolution approving a Clean Water State Revolving Fund, or CWSRF, financing agreement for the City of Dixon in the amount of $28.5 million. The city is located in Solano County, approximately 25 miles west of Sacramento. The city owns and operates a wastewater treatment facility. The facility consists of headworks, 9 unlined treatment ponds, and 4 polishing ponds. Treated wastewater is disposed using 8 percolation ponds. The ponds have a total surface area of 280 acres. Beginning in 1996, the Central Valley Regional Water Quality Control Board, or Regional Board, has taken several enforcement actions against the city for noncompliance, specifically for salinity constituents. These actions include issuance of cease and desist orders, notices of violations, administrative civil liability orders, and fines. On August 8, 2014, the Regional Board adopted new waste discharge requirements and a companion cease and desist order. These orders require the city to complete wastewater treatment plant upgrades by December 2016 and comply with effluent limits by July 2017. The proposed project will replace the current pond treatment system with an activated sludge treatment process. This process was chosen over the other alternatives considered because it would greatly reduce evaporation and not require additional treatment for salinity reduction. Construction includes a secondary activated sludge treatment process using oxidation ditches, a new pump station, headworks, laboratory and administration building, solids handling facility, general piping upgrades, and the removal and disposal of approximately 2,000 tons of sludge that has accumulated in the existing treatment ponds. In April of this year, the City Council increased the monthly sewer charge consistent with Proposition 218 guidelines from $24 a month to $49 a month by 2017, and also pledged net revenues for payment of the CWSRF loan. The Solano County Taxpayers Association, or SCTA, Dixon chapter, subsequently circulated 2 petitions demanding that the city either rescind the rate increase and pledge or submit them to the voters for approval or rejection. Approximately 18% of the city's registered voters signed the petitions. On June 10, 2014, city election officials rejected the petition to repeal the rate increase on procedural grounds and took no action regarding the pledge of net revenues on the basis that the referendum constituted an invalid interference with the administrative acts of the city. On July 14, 2014, the City Council, on its motion on authority, considered whether to submit an initiative to the voters regarding the sewer rate increases. The City Council voted to reject this motion on a 3-2 vote. I will now turn this over to our attorney, David Rice, to discuss the most recent development on the sewer rate increase.
Good morning, David Rice with your Office of Chief Counsel. So as Wendelin said, until about 10:45 last night, there didn't appear to be a live issue regarding the sewer rates. However, about that time, we were notified by the City Attorney's Office that the Solano County Taxpayers Association had notified them that they plan to circulate a petition to get an initiative on an upcoming ballot to roll back the sewer rates. So we received that information last night. If they were successful in rolling back the rates, then they wouldn't be able to repay the loan, and they wouldn't have, the city wouldn't have sufficient revenue stream. The initiative process requires several procedural steps, so this is just the beginning, and it includes gathering a certain amount of signatures. I don't exactly know what the percentage is right now, but I think it's a higher hurdle than their initial attempt to roll back the rates. So it's, at this point, it's fairly speculative to know, how successful this challenge will be, but nonetheless, it has been initiated. So it does create some heightened risk here. However, in all the financing agreements, there are procedural safeguards and provisions that protect the fund in events of challenge. And so under the standard language, there is the State Board has the authority to evaluate risk when there's a challenge and to exercise discretion when and whether to disperse funds. So there is already language in there that can be used to protect the fund and to kind of monitor the situation. So at this point, I wouldn't recommend any additional language because the language that is necessary is already in the ISA, but I did want to at least highlight this issue, and I suspect that the city attorneys from Dixon may speak a little bit on this, as well as the Solano County Taxpayers Association.
Good morning, Chair Marcus, members of the board. Christopher Stevens, Supervising Engineer with the Division of Financial Assistance. I just want to add a few comments to the staff presentation here. Of course, as a general matter, there is a certain amount of risk with all clean water SRF loans. And so the real question is the level of risk acceptable? We're aware of the history of the disagreement within the community over the project and their efforts to meet the regional board orders. We have had many conversations, long conversations, as we've gone through our due diligence, reviewing the application, to try to assess the level of risk associated with this history. As David has alluded to, there are many standard conditions in our standard agreement that address this issue, the security of the loan and repaying the loan and all of those questions. Two questions that were uppermost in my mind as we were going through this deliberative process was, number one, should we even recommend to the board that the Clean Water ESSER finance the project at all? And related to that is, are there any special conditions that we can recommend that the board put on the agreement in order to try to ameliorate some of these risks? You know, and as David has alluded to, there isn't anything specifically that we can point to concrete as a condition to put in the financing agreement to try to lessen this risk. So our recommendation is that the board go ahead and approve the financing, but of course we will be monitoring the situation very closely and working with the city as this process plays out and taking appropriate action based on the circumstances that come up.
Both of you have alluded to the general conditions that are always there. What are those? Do those just say that the loan, I mean, what do they? I'm
Sure.
sort of left in the dark a little bit. I can guess what they might be, but it'd be helpful if one of you explained
Sure,
what they
sure.
are.
A great question. So there are two provisions. One is that the board may withhold disbursement of funds if there's the threat of a material breach. And so what constitutes a material breach is fairly broadly defined, but it includes an initiative to roll back the rates and other actions taken to roll back the rates. So the agreement already authorizes the state board to withhold funds if they think there's a threat to the ability of the recipient to actually pay them back. And the second is, and it's related, if there is an attempt to roll back sewer rates, the city is, or the recipient, I mean the city in this case, but the financing recipient is required to monitor the situation, provide updates to the state board, and also is generally required to get involved and try to defend and uphold the sewer rate, so actually litigate based on a request from the state board, and also to update the state board. So those are the two provisions that I was considering having pretty good safeguards.
And let me just make a slight modification to something David said earlier. So it isn't an all-or-nothing proposition. We're not going to give the city $28.5 million on the first day. There's going to be a series of disbursements.
Right.
And so there is a time element to this, and we will have an opportunity to, you know, see how things play out as we are dispersing funds. The city is not, you know, it's not that it has zero money. If the rates were rolled back, they would not be able to repay the entire loan, but if we disperse some of it, you know, that depends on the numbers, of course.
All right. Other questions before we hear from the public? Then we'll have more, I'm sure. First, we have Jack Batchelor, the mayor of the city of Dixon. Mr. Mayor.
Thank you, Madam Chair and members of the board. The staff report is very accurate. The city of Dixon has been working to mitigate our wastewater disposal facility since 1994. I became involved in it in 2006 when I was first elected to the city council. Then in 2008, I continued in that capacity as elected mayor, and then again in 2012 as a re-elected mayor. During that period of time, we have taken great strides, or made great strides in reducing the amount of salinity that is in our effluent. We've worked very collaborative with a regional water quality control board to do that. We've also established a citizens group on wastewater. This group met for numbers of years with our city staff and Stantec, our consultant, to look at ways to reduce the salinity without causing an undue burden upon the ratepayers. And so the result of that is the activated sludge process. Now, you may hear that we have not looked at all of the issues, that we haven't looked at other possible treatment solutions that are less costly. Well, we have. We've looked at deep well injection systems, which I think there may be one example of that happening. I'm not sure it's in California. I'm not sure that it even would pass the Environmental Protection Agency standards. But it's also very costly, much more costly than a wastewater treatment solution that we have proposed. The second was recently a company called Inpipe coming in and introducing microbes into the influent, which would then help reduce the bacteria, which would assist in the actual effluent being reduced in terms of salinity. We had a special council meeting, which the public was invited, and it was well attended. And that special meeting was entirely on the Inpipe process. And each of the participants or the principals from Inpipe said that utilizing a activated sludge process was the best process for Dixon's issue. Their process could aid us in reducing some of the amount of sludge that we would have to dispose of, but their system was not a standalone system in our case, because they could not meet the discharge rates that have been recently adopted by the Regional Water Quality Control Board. So I'm very confident that the citizens of Dixon will realize that we need to go through this. We've already had several fines. We run the risk of losing the ability to do our own destiny, if you will, if we don't follow through with this one. State certainly has the opportunity to come in, do it anyway, and impose the rates. So I encourage you to adopt the staff recommendation and allow us to move forward with this project. Thank you very much.
Thank you.
I'll be happy to answer any questions if you have any.
Right. Just stay
All right,
tuned.
thank you.
We'll see. Michael Caramello, if I pronounce that, or Sarah? Please tell me how to pronounce it, from Citizens of Dixon.
Yes. My name is Michael Chiramello,
Oh, Caramello, sorry.
and I was a former councilman. I was also a member of the wastewater committee that the mayor spoke of. The wastewater committee was dissolved because the mayor didn't like the fact that they recommended not proceeding with this project because the state has not come up with final effluent limits and any number of other reasons. Inpipe is not a total solution. Neither is activated sludge. It takes no boron out of the effluent, and you're simply allowing the solution being dilution to pollution, which Ms. Creedon of the State Water Board, the Central Valley Water Board, and Wendy Wiles of the State Water Board informed us was not a solution. Now, just recently on their agenda, they had a resolution number R5 2014-0074. And under number 5, it says, in addition, because reevaluation of water quality standards that underlie effluent limitations is not an action leading to compliance with limitations, compliance schedules are not an appropriate regulatory mechanism. More or less what they're saying is you shouldn't be going out with final effluent limits until you have all the research from CV Salts, your consortium that you put together to find out what the carrying capacity of soils is and all the rest of it. I just have some brief points I want to make. First off, they had a hearing, I believe it was last week on the 8th.
The regional board or the
Yes,
city?
the Central Valley Regional Board. They disenfranchised us by moving the hearing up so that we could not present the information we had. Not only that, Mr. Paloopa, Patrick Paloopa, who is the chief counsel for that water board, in addition to saying that he doesn't work for us, even though we pay his salaries, said that Inpipe was not a solution and it would not work in Dixon. That is totally incorrect. They have and they have pulled out, they have a proposal in, I've talked with John Williams, the president of Inpipe, and they're proceeding along with this. Inpipe is a bacillus treatment which can remove 50% of the solid waste going down there and remove nitrates, just what activated sludge does. No, it's not a total solution. If you want boron out, and this is the difficulty with dealing with your boards. Mr. Paloopa also advised the chairman, Carl Longley, not to read information that I attempted to provide him on ferrate treatment. And I have several things here on ferrate treatment. Ferrate treatment ferrate is a supercharged iron molecule in which iron is in the +6 oxidation state. It is better known as iron 6. Ferrate is extremely powerful, can deliver multiple treatments from a single application, does not create disinfection byproducts, is environmentally friendly, and solves difficult treatment challenges that other oxidants can't touch. Most importantly, Ferrate is often the least expensive and most effective treatment option. The cost is estimated at $1.35 million to put this in. It removes heavy metals, and I took the liberty of printing this out for you so that you could, well, actually, I wanted it to go to the other board, but it was very interesting, the stuff that this takes out. Pesticides, 2,4-D, 2,4,5-T, Dursban, rotenone, metal cations, aluminum, arsenic, barium, cadmium, calcium, cobalt, copper, lead, manganese, and manganese is on the target now, according to what I've been hearing from the State Water Board. It's a new constituent of concern. The problem with what Mr. Batchelor said about 1994 is this has been a moving target. Every time we come up and solve a problem, and it wasn't the city that solved the problem with the salt, it was the taxpayer group that got up with Mr. Salty in front of their water board and said, you have a problem. We can't regulate salt water regenerating water softeners. And we want to be able to do that. We got the law changed at the state level to do that. And that's what we did. We had them removed from our system. We paid bribes to the people to get rid of these things, and we greatly reduced our effluent limits, as far, not effluent limits, but effluent amounts for calcium, not calcium, excuse me, sodium and chloride. In addition to this, there's also a study on Lake Apopka from Ferrate treatment. Lake Apopka is Disneyland's lake. It was grossly polluted from pesticides, fertilizers, etc. And on their little sheet of what was taken out, it has boron, 43.5, well, let's see, it was 101, 43.5 afterwards. That's a 57% reduction. Now, the city is going to say that they have examined all solutions. They haven't examined this solution. They refused to examine the solution. We had to drag them through the streets to get them to examine in-pipe. And yes, we are going to proceed with this initiative, and it will be rolled back. The only difference is we have been telling the state all along. I wrote to Bob Pontareri myself and told him what we were doing because we know the way this works. They take us to court and they say, well, we've already got this thing on board, and therefore you have to throw it out. No, that's not going to work. First off, activated sludge is not the best practical treatment that's available. This is. In combination with the other, not only do you remove stuff from the water, but you don't have to clog up our landfills. Haven't we been talking about landfills are a problem, that they're filling up too fast? You're going to take 200 or 2,000 tons of sludge out that's been in a stasis condition where it's being dissolved biologically. And by the way, in-pipe also has a thing to activate that sludge in the ponds where it is to remove it or dissolve it, gets rid of like 50% more of it.
Right, Mr.
Yes, sir.
Chair, can you wrap your comments? I get that you disagree with the choice the city is
Right.
making.
Right. I think I've hit all of the points that I wanted to make. I simply want to summarize and say, there are better solutions out there. This is premature. It never should have happened. We should have been able to testify in front of the water board, and we weren't allowed to. And actually, I contacted an attorney about that, and he was the one who gave me the term disenfranchisement. I think that at this point, you do not need to consider giving a loan out until these other methods are examined and found to be pertinent and a much better solution at a much cheaper cost. We have no problem paying for headworks and the rest of that. Matter of fact, we approved a rate increase as the wastewater committee. We approved that increase to fund the current ratepayers' portion of those costs. Now they want us to pay for future development's costs. That's what this is all about. They can't get their projects done. That's it. Thank you very much.
Thank you,
And,
sir.
oh, would you like me to return this material into your clerk so
What?
that you have it to look at?
Yeah, definitely.
All right, thank you.
Gary Riddle, Dixon Chapter of the Solano County Taxpayers.
Good morning. I'm Gary Riddle. I am president and represent the the Dixon chapter of the Solano County Taxpayers Association. We are opposed to the approval of this state revolving fund loan, and as stated, have filed a petition to circulate an initiative to amend the ordinance that increased our rates. Naturally, these rates will be used to pay back the loan. So as stated also, we did collect signatures successfully for a referendum. It was denied based upon a technicality of involving staples, and but based upon that, we feel we will be successful in collecting the signatures to put on the ballot, and that and the mood of the citizens in Dixon. I'm not going to go into, and I wasn't actually prepared to go into all those technicalities, and I'm glad Mr. Charamello brought them up, because those are the real crux of the issues. The taxpayers, we're not the enemy. We want to do the best for our community at the lowest cost for our citizens. Our citizens are the real stakeholders. They're the ones that pay the bills. Just to give you a little bit of background, we have been involved heavily in this issue since 2006. We did sponsor an initiative to deny a rate increase, or repeal a rate increase, I should say, for a $40 million project that, again, we did not feel was the solution. And as a result, the voters did approve that initiative, denied it, and based upon that, the Regional Water Board fined the city of Dixon for having the audacity to repeal the sewer rate. And that project was proven to be a Band-Aid approach and not a real solution. We have similar feelings about this project. Based upon that, and as Mr. Batchelor pointed out and was spoke to, a wastewater committee was formed, and that committee was made up of members, included members of the taxpayers. I was on that committee also, and we studied these issues for several years. The first year, or well, about a year and a half, we met every Monday night for approximately 3 hours and went over all these issues. The committee did not vote to approve this activated sludge project, which is the main source of this funding.
Excuse me, I'm just curious, are there any registered professional engineers on their committee doing review of treatability studies?
Yes, we did have at least one that I'm aware of.
Okay, thank you.
And let's see where I was. Did not, lost my place here.
That's good.
Do you have a name? I mean, is there anybody's license?
Yes, that's right. One was our former city engineer, and the other is a gentleman at this point, unless he wants his name divulged, he worked for the state in this business.
Okay, I appreciate it.
So, moving on. Based upon our denial of this, not to approve this project, the council voted to dissolve the committee. So put us out of business and then approve the project. Let's see, legislation. We were very active in supporting the legislation that banned the salt-activated water softeners. We did support, the committee did support, and the taxpayers did not object to a 2008 rate increase because we felt that it was a useful project. That part of that funding for that rate increase, which has been in effect since 2008, was to repair, replace the headworks, which you just heard mentioned is again in this rate increase. And one of the things that I was very convinced on that headworks, they mentioned the current headworks was not earthquake sound, and there were safety issues for the workers. That was very convincing. That project hasn't been done. The citizens have been paying their share for that project since 2008. So again, just my closing comments here, I'd like to say that our objective is support the citizens. We want low costs. We want good projects. We're not opposed to just on the, just arbitrarily opposing projects. We've supported projects. We've helped the city by involvement. But we are requesting the denial of the loan until the citizens have had an opportunity to vote on this initiative. Thank you. Thank you very much.
Dave Eckel, publisher of Dixon's Independent Voice. That's the name of the paper?
Excuse my handwriting, it's Dave Scholl, like the foot doctor.
Oh, it's an S, sorry.
That's an S, okay.
Thank you.
I'm here in several capacities. I am the publisher and editor of Dixon's Independent Voice, which I've been doing for the last 19 years. Obviously, I reside in Dixon.
Oh, and one thing to tell you, Mr. Scholl, you asked for 10 minutes. I can't give you 10 minutes. As you see, there's a room full of people behind you. I'm going to give you 3, and I've been generous on that.
It's probably not enough, but
Well, that's,
okay, well-
that's all you're going to get today. I'm sorry.
the key points I'm trying to make
Yeah.
are that the people in Dixon are the stakeholders, the ratepayers, the taxpayers. The people in Dixon are rightfully believing that they are not being treated as the rate or the stakeholders. We have not received the information. The state had not been proactive in communicating with us. They didn't communicate with me, the locally owned newspaper in Dixon, all these years. If you read your report that was presented to you today, it looks like the Taxpayers Association are being just putting their backs up and refusing to go along with anything. You read where it says that the ratepayers rejected the rate increase in 2006. What it doesn't tell you, which the previous speakers alluded to, is that was to fund a truly stupid project, which was to spend $40 million to bring a pipeline south of Dixon and release the effluent there where the groundwater isn't as clean, supposedly, at the sewer plant. And it used data for the sewer plant based on test wells miles upstream, use that term, from the plant. The people knew they didn't test it properly, they were using the wrong data, and they had a plan that made absolutely no sense, and it was expensive. We were fined immediately after that vote was taken, out of spite, vindictive spite, by the water board. One thing that people want in Dixon, we want our money back because we have been proven right. And we are being proven right in this case. You've heard the city and the water board trying to take credit for things that have been progressed. Every one of those progressions has been because of the Taxpayers Association and the citizens. We pressured the city into setting up a Citizens Water Quality Board. That board found out the problem was salinity, and the problem was the water conditioners. We went to the legislators, and it took 2 years to do it, but we pressured them to change state law so we could get rid of those. And it worked. It reduced the salinity to where we were in compliance. Then we found out, just the beginning of this year, about in-pipe. They had presented that information to the city 4 years ago while the Citizens Water Committee was there. They didn't tell the Water Committee. They didn't tell the City Council. We found out about it, looked into it, researched it, and we found out it was going to dramatically help Dixon. Now we found out about the ferrate treatment. All along, the city staff and the water board staff have ignored modern technology. We can take care of it less expensively. Now, I want to point out a couple things in a policy which was adopted in June by the Water Quality Board. One is a statement that compliance schedules are not an appropriate mechanism. This is in your resolution, or Region 5 Resolution 74 for this year. When the water quality standards may be revised so that the more stringent permit limitations are no longer applicable. You also said, your staff said in the second page, item 8, the need exists to set current permit limitations at a level that protects water quality, but that does not compel the irretrievable commitment of major resources in advance of completion of the salinity test that you're doing. $30 million is an irretrievable major commitment. To do this now violates your own policies. Now, the other thing I want to point out is,
And if you don't mind wrapping.
okay, what the
that's
city
okay.
has given
That's-
you,
It's helpful, but,
what the city has given you is padded. They include numerous items, which a previous speaker mentioned, which are already funded by a rate increase. They're including it in what they want to have funded by this loan. They also include $1 million in administrative fees. Those are payments to city staff, which we're already paying and should come out of current fees that are being collected. There are several other things too. If you take a look at what their list is, it's $2.7 million contingency fund, $4.5 million project management, actual construction $18 million. And if we use this more modern, more efficient, less costly technology, this can all be done for dramatically less. But they're asking you to give us a long-term 20-year loan to pay for current expenditures that should be paid for out of current rates and not through a loan. I can tell you, I have my pulse on the people of Dixon. I followed this throughout the whole process, and so have my writers. The speakers who just talked to you, were right. This is premature, it's inefficient, and it does not take anything out of the affluent. There are affordable processes that do. So we're asking you not to adopt this loan now and to let us proceed with coming up with a real plan that will solve it. The taxpayers have been actively involved. We've been writing about it and been involved in it. We're not just putting our backs up. We are actively and proactively involved in solving the problem more than the city staff. Thank you.
thank you, sir. Next, Steve Churchwell from the city of Dixon.
Madam Chair, we'll try to kill, my name is Doug White. I'm the city attorney for the city of Dixon, and Steve Churchwell is my partner, and he's an election law expert in the state and the former general counsel for the Fair Political Practices Commission. We're going to try to do this at the same time to keep this brief and efficient and
Okay.
answer any questions. First of all, I'd like to thank your staff because it's not many state agencies that I work with that I get emails and replies back at about 10:30 at night. So let me start off by saying that I wanted to note your staff and their commitment to this. I also wanted to clear up some stuff because there's some things that have happened in a very short period of time, and we're very familiar with initiatives and referendums and how those work. And so I wanted to just clear up some information as we go forward. Number one, you can't use an initiative to roll back rates. The rates that have been adopted are already in effect. They have been in effect. You could potentially put them back to the way that they were, but what's being collected and what is being collected until an initiative was passed would stay in effect. So you can't necessarily roll back rates. It's only a going forward type of deal. And I also want to note, so that to give you some comfort, the rates that were in effect prior to the ones that are in effect now support all the design work and the things that are going to be paid for up front. So there's some assurance that the existing rate structure that was in place even before, while it wouldn't have supported the construction, it would have supported the design work. So I think that the board can feel some comfort knowing that. Second, an initiative can't be put in place that causes the city or any government entity to breach a contract. So I want to clear that up as it relates to this SRF loan. You can't use an initiative to cause a breach of contract. There's a whole series of cases on that, and I think that should give the board some additional security. And as it relates to, I think of what you've heard from the taxpayer group is a lot of discontent with the solution that has been chosen. But the way that it works is the city council is the one who's given the discretion to choose that solution. And while they can certainly disagree with it, it's the city council's prerogative to choose whatever. They could have gone with a much more expensive process. They've chosen the one that's before you today, and that your staff has looked at and has recommended for approval and support with the loan. Third, frankly, even as it relates to the referendum, and we've been very forthcoming and done memos to the Taxpayers Association ahead of time, the initiative as proposed is unconstitutional. First of all, it's dealing with, it deals with administrative acts, and this action that's being taken is also being taken pursuant to the cease and desist order with the Regional Water Board, and pursuant to a regulatory mandate. There's a series of laws that goes into how you have to fund those things. You can't underfund those things. And if we don't do the rate increase and we're not able to comply, we're looking at two different situations, one in which either the citizens will pay much higher rates because of penalties that are imposed on them, and or you all come in and kind of get more active and take over and take some discretion away from us, or we'll just be insolvent, and that's a much bigger problem. So so this really is the right time. So it's been going on since 1994, and there's been a lot of thought process been put into this solution. And I also want to remind you that there was a 218 process that we did go through, and an insufficient amount of signatures were collected as it related to that. So that was the real opportunity to roll that back. If they wanted to stop this, they should have gathered the 218 signatures. They came up short on that. As it related to the referendum, it was defective. It didn't include things like what the rates were going to change to, really basic information. Over 1,000 signatures, or 900 some signatures were collected, and only 8 cover sheets were provided with the signatures, and we're not allowed to go and do research and figure out if they would do it. It was facially defective.
And can you also we're not going to litigate the.
No, I just wanted to give you.
We're not going to decide the issues that you all are going to be dealing with.
No, I
in the
just wanted to give you
appropriate form.
comfort. Yeah. The main issue here is to give you comfort that the city of Dixon stands ready, willing, and able to repay this loan, and we would appreciate your support for that, and we're here to answer any questions if you have any.
I think you'll be pleased to hear I have nothing to add.
All right, thank you. Thank you for being, well, I mean, it's important to hear it from folks. Questions from my colleague. I'm looking at Mr. Moore, who's built and designed these things. I've spent my career fighting over treatment levels as sewage treatment plants when I started a couple of years ago. I know these issues can be hard felt, and I've used some of those products to get improved treatment capacity, but not in lieu of activated sludge. So I know probably just enough to be dangerous in this arena, but let me turn to my colleagues and see if they have any questions for speakers or staff.
I just think context is helpful, but I really have a lot of faith in staff, in your knowledge of, the different treatment processes throughout the Central Valley and the state, but activated sludge, how many plants in the Central Valley use activated sludge? 100? Yeah, hundreds. Yeah, and the engineering profession, we are by default very conservative because we have to put our licenses on the line in terms of certifying that something's going to work on and into the future and not cause problems. And activated sludge is one of those middle of the road, tried and true, proven technologies. And so I'm struggling. But, I like Chair Marcus, I appreciate the passion and the open-mindedness to new ideas, but that runs counter to the engineering tendency to specify those things that we know will work and will be cost-effective. I noticed the oxidation ditch component, which is a nice low-tech, low-cost type, part of the treatment train. But I don't want to, it's not my place to do a value engineering of the approach. I'm just, from staff standpoint, you're convinced there was an adequate treatability study performed?
Yes, my understanding is that the city's engineer is here, so they can speak to this more specifically. But yes, that's part of the application, is that people submit a feasibility study and examine alternatives and life cycle costs, and try to come up with the best options there.
Yeah, right. Yes, and just that's really all I wanted, is just a staff to affirm, the procedures were followed, were above board, transparent, and I appreciate that, and appreciate staff's recommendation on this. And is there any other discussion?
No, I appreciate the comments from Member Moore and staff's affirmation, and I'm prepared to move the item for adoption.
Second. All right. These things are challenging at the local level. It's one of those things where I think for us, loath to step in and second guess the decisions made at a local level, but I do think that the decisions are well within the norm of what we see. So just wanted to say that. So with that, all in favor?
Aye. Aye.
Aye.
Any opposition? Thank you. And thank you for your time. All right, we will now take a break. My apologies for not doing a mid-morning break. I misestimated the time. I'm sorry for those of you who had to leave. And can we come back at 12:30 and call it the lunch break? Is that all right? Let's do that.